Are we ready to proceed? Mr. Bull? You ready?
Yes.
Ms. Branstad?
Yes, Your Honor.
You can get the jury, please. You may be seated. Thank you. Good morning, ladies and gentlemen. I apologize for keeping you waiting this morning. Ms. Branstad, any further evidence or testimony on behalf of the defendant?
Your Honor, the defendant offers exhibits A, B, and AC.
No objection?
Exhibits A, B, and AC are admitted.
And Your Honor, the defense rests.
Very well. Does the state have any rebuttal evidence?
No, Your Honor.
Very well. Ladies and gentlemen, that means the evidence is done. As the saying goes, it's all over but the shouting. I think the attorneys will keep their voices to a moderate level. What we are going to be doing, the attorneys and I were both, we were up late last night, up early this morning trying to get things ready for you so you wouldn't be sitting around waiting for us. And we are ready to proceed into reading the instructions, which I will be doing. I would ask Lori if you could hand out those copies. I asked Lori to make 7 copies of the instructions. You're going to have to share with your neighbor. You can follow along if you want to. You don't need to follow along if you don't want to. You will have copies of the instructions to take back to the jury room with you to refer to during the course of your deliberations. I would indicate, Ms. Larpenter, you do not need to report the reading of the instructions. So, ladies and gentlemen, these are the instructions. The trial information charges the defendant, Jason Gene Carter, with first-degree murder. Jason Carter has pled not guilty to the charge. The trial information is the document that formally charges Jason Carter with a crime and is merely the method by which Jason Carter is brought into court for trial. It is not evidence. 1. Jason Carter has entered a plea of not guilty to the charge. A plea of not guilty is a complete denial of the charge and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove Jason Carter guilty beyond a reasonable doubt, your verdict must be not guilty. 2. Jason Carter is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of Jason Carter. The presumption of innocence remains with Jason Carter throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. 3. In this case, Jason Carter has decided not to testify. Jason Carter is not required to testify, and no inference of guilt shall be drawn from that fact. The burden of proof remains upon the state to prove the guilt of Jason Carter. 4. You must determine whether Jason Carter is guilty or not guilty from the evidence and the law in these instructions. My duty is to tell you what the law is. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Your duty is to accept and apply the law and to decide all fact questions to determine if Jason Carter is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. You must consider all of the instructions together. No one instruction includes all of the applicable law. As you consider the evidence, do not be influenced by any personal sympathy, bias, prejudices, or emotions. Because you are making very important decisions in this case, you are to evaluate the evidence carefully and avoid decisions based on generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands you return a just verdict based solely on the evidence, your reason and common sense, and these instructions. As jurors, your sole duty is to find the truth and do justice. 5. You shall base your verdict only upon the evidence and these instructions. In this case, the evidence is the testimony given by the witnesses, the exhibits received by the court, and any stipulations of the parties. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Sometimes during a trial, references are made to pretrial statements and reports or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items which were referred to but which were not offered and received into evidence are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers, objections and rulings on objections, anything you saw or heard about this case outside this courtroom, and anything I told you to disregard. 6. You must decide the facts from the evidence. The weight to be given any evidence is for you to decide. Consider the evidence using your observations, common sense, and experience. You must try to reconcile any conflicts in the evidence. But if you cannot, you may accept the evidence which you as jurors find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony to believe. For example, whether the testimony is reasonable and consistent with other evidence you believe, whether a witness has made inconsistent statements, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts, and the witness's interest in the trial, their motive, candor, bias, and prejudice. 7. Exhibits have been admitted into evidence and are to be considered along with all of the other evidence to assist you in reaching your verdict. You are not to tamper with the exhibits or their contents, and each exhibit should be returned into open court along with your verdict in the same condition as it was when received by you. 8. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. 9. You have heard evidence claiming witnesses have made statements before this trial while not under oath which are inconsistent with what the witnesses said in this trial. Because the witnesses did not make the earlier statements under oath, you may use them only to help you decide if you believe the witnesses. Decide if the earlier statements were made and whether they were inconsistent with testimony given at trial. You may disregard all or any part of the testimony if you find the statements were made and they were inconsistent with the testimony given at trial, but you are not required to do so. Do not disregard the testimony if other evidence you believe supports it, or if you believe it for any other reason. 10. You have heard evidence claiming witnesses have made statements before this trial while under oath which were inconsistent with what the witnesses said in this trial. If you find these statements were made and were inconsistent, then you may consider them as part of the evidence, just as if they had been made at this trial. You may also use these statements to help you decide if you believe the witnesses. You may disregard all or any part of the testimony if you find the statements were made and were inconsistent with the testimony given at trial, but you are not required to do so. Do not disregard the trial testimony if other evidence you believe supports it, or if you believe it for any other reason. 11. Evidence has been offered to show Jason Carter made statements at an earlier time and place while not under oath. If you find any of the statements were made, then you may consider them as part of the evidence and use them for any purpose. Statements and questions by law enforcement officers during interviews with Jason Carter are not evidence to be considered for their truth. 12. Jason Carter claims the state intentionally destroyed or failed to produce certain evidence consisting of a fly egg clutch found in Shirley Carter's nostril at the autopsy. The state denies it intentionally destroyed or failed to produce the evidence. If you find that the fly egg clutch existed and the state knowingly and intentionally destroyed this evidence without satisfactory explanation, you may, but are not required to, conclude the evidence would be unfavorable to the state and favorable to Jason Carter. 13. Jason Carter contends a reasonable doubt is raised by reason of the state's failure to do an adequate job investigating the death of Shirley Carter. In support of that contention, Jason Carter offered into evidence certain statements made by witnesses to law enforcement officers during the course of the investigation. You should not consider these witness statements made to law enforcement officers to be true. Rather, you may consider these statements only for the purpose of determining whether law enforcement officers properly considered and followed up on the witness statements they received during their investigation. 14. The burden is on the state to prove Jason Carter guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case or from the lack or failure of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, and not the mere possibility of innocence. A reasonable doubt is the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt, therefore, must be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it. However, proof beyond a reasonable doubt does not mean proof beyond all possible doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of Jason Carter's guilt, then you have no reasonable doubt and you should find Jason Carter guilty. 15. The state must prove all of the following elements of murder in the first degree as alleged in the trial information. 1. On or about June 19, 2015, Jason Carter shot Shirley Carter. 2. Shirley Carter died as a result of being shot. 3. Jason Carter acted with malice aforethought. 4. Jason Carter acted willfully, deliberately, premeditatedly, and with a specific intent to kill Shirley Carter. If the state has proved all of the elements, Jason Carter is guilty of murder in the first degree. If the state has failed to prove any one of the elements, Jason Carter is not guilty of murder in the first degree. 16. As used in element 4 of instruction number 15, willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Deliberation and premeditation need not exist for any particular length of time before the act. 17. Malice is a state of mind which leads one to intentionally do a wrongful act, to intentionally, there's a repeat right there, I apologize. Let me start over. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of Jason Carter and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Malice aforethought may be inferred from Jason Carter's use of a dangerous weapon. 18. For Jason Carter to know or have knowledge of something means he had a conscious awareness of it. Specific intent, as used in these instructions, means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining Jason Carter's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine Jason Carter's specific intent. You may, but are not required to, conclude a person intends the natural results of his acts. I am going to read the rest of the jury instructions to you at the close of the closing arguments, So if you can maybe just put those on the floor next to you. As you will note, I asked Lori to take away your notepads. We want you to just sit and listen carefully as the attorneys give their closing statements, which they will now be presenting. Counsel for the state will have the opening summation. Counsel for the defendant will then have an opportunity for reply, and since she will only address you once, she will also present her summation. Counsel for the state will then have a closing summation to the argument made by counsel for the defendant. Attorneys for each of the parties will be summarizing the testimony that you heard and the evidence which was presented during the trial. They will be recalling the evidence as you will later. They will not try to mislead you, and if their recollection of the testimony is not the same as yours, you must follow and rely on your own recollection. The summations are merely that, summations. They are not evidence, they should not be considered by you as evidence, and they are not instructions on the law of this case. They are intended to help you in understanding the contentions of each of the parties. You should give them your undivided attention,